Let's go to 167, 168, and 169. Counsel, you're going to argue in Conceicao?
Yes, Your Honor.
Okay.
I'd like to reserve 2 minutes.
2 minutes? Go ahead, you're on. First of all, tell us, how does your case differ from the others?
My case, first of all, my case is exactly like Terrell in every single.
Well, I mean the other two that's being heard today.
The other two, I believe, one has to do with whether Boykin rights apply to a violation. One has to do whether it applies to a misdemeanor. In my case, it is identical and indistinguishable in every way from Terrell. Appellant pled guilty, was sentenced immediately at arraignment. It was a record that was completely silent. There's no indication he was ever given Boykin rights. There's no indication he ever consulted with counsel.
What year was your case on?
My case was 2009, Your Honor. And Terrell also did not create a new rule of law.
Well, that's the question. Is it a new rule? Is it a bold departure?
It's absolutely not a new rule.
Tell us why not.
I'll tell you why not, Your Honor. First of all, Terrell merely applied the longstanding principles of Alabama v. Boykin, which was decided in 1969, People v. Harris, 1983, People v. Fumafredo, 1993, that there has to be an affirmative showing on the record that the defendant waived his Boykin rights. Recently, this Court reversed in People v. Moore in an identical case. I understand.
But do you want to reverse this and go to trial? Is that what we're looking at?
No, we want to.
Why wouldn't we go to trial? You know, as you know, I dissented in Terrell, and one of the things is that, from experience, I know a lot, not necessarily your client, but there's a lot of people that get me out of this thing. You know, I'll take the impaired, you know, and you go in and you plead them guilty to impaired, and now somebody says, well, gee, you didn't tell me that I had a right to a jury trial, et cetera, which the remedy would seem to me to be, okay, we'll go back to square one and we'll let you go to trial on your DWI. That's the last thing I want. And so what I'm concerned about in these cases is that we don't make a joke out of the legal process. If you really sincerely believe that because you didn't get your Boykin rights, you did something you would not otherwise have done, that's understandable. But if all you're doing is saying I'm taking a plea because I'm getting time served and they caught me red-handed, but now I can try to get, you know, the whole thing thrown out into technicality, I would think you'd agree with me. That's not a good thing.
Well, Your Honor, first of all, I don't think it's a technicality. These are important constitutional rights. This case is exactly the same as Terrell. It's exactly the same as Moore. And they're indistinguishable. So the same results should apply. And in terms of remedy,
you say that, counsel, as you started to say, because the plea was taken at arraignment, there was no opportunity to consult with counsel about the plea or to find out anything, essentially, at least not on the record.
There's nothing on the record. That's right, Your Honor.
Absolutely. That's the key, that the silence in the record is
completely silent record.
Is what you're basically relying on.
Absolutely, and that's the key.
But isn't the question of the new rule about preservation? Not for Boykin rights. Boykin rights, you're correct, well established decades ago.
There is no new rule with regard to preservation, Your Honor. First of all, in People v. Lopez, this Court found that there's no preservation required where the record called into question the voluntariness of the plea. Subsequently, in Terrell.
That's not the issue, because in Terrell there was the analysis in Terrell was either using the Lopez-Lurie exceptions, and there I think you're right, where it wasn't whether the record was silent, or if the record itself, if the plea and the sentence occurred at the same time, I think then once again that a defendant wouldn't be able to do it, and you're within the Lopez-Lurie exception area. But it also made reference to a mode of proceeding error. And one of the things perhaps that we have to clarify, whatever happens in your case, is what's the proper preservation rule. One would create a new rule, and one wouldn't. So you see the problem.
I mean, I think the mode of proceedings error, I think Lopez was a mode of proceedings case. I think that the mode of proceedings language followed from Lopez, and you're absolutely right, Your Honor. In terms of Lore, in terms of the practical inability to object, you had Lore. You also had McAlpin, which was decided in 2011. We had Peke. So this is a very, very well-established principle of law. And all the court was doing was taking this series of cases.
So really, you're characterizing it then as falling within the whole line of cases going all the way back to Perez, where we look at the totality of circumstances, and not a per se rule that you got to read these rights or don't read the rights. But in these circumstances, it's not a new rule. It's an application of our old law to new circumstances.
Exactly. I mean, these are well-established principles, and all you're doing...
Which makes it retroactive.
Which makes it retroactive, Your Honor. That's exactly right. I just want to briefly, with respect to the people's other argument that somehow this is a new rule regarding misdemeanors, there are absolutely no cases saying that. They haven't cited any cases saying that.
Why is it the same whether it's a serious crime or a misdemeanor?
Well,
what do they have in common?
Well, I think a misdemeanor is misdemeanors are serious in the sense that there are potentially serious consequences. You could be deported. You could face loss of housing. You could face loss of benefits. So
the loss of liberty in and of itself is not the determining factor.
Misdemeanors are serious, and there's absolutely nothing saying that Boykin, that this is somehow a new rule and that Boykin rights shouldn't be given under these circumstances. I would just like to say, even if, and absolutely this is a new rule, and that should be the end of the analysis. It is not a new rule. That should be the end of the analysis. Even if, just for the sake of argument, this was a new rule, which it isn't, the federal rule under Griffith v. Kentucky should apply, not the Pepper rule. Pepper only applies if no federal constitutional principles are involved. Here, Terrell involved federal constitutional principles, that you need an affirmative record, that the defendant waived his federal constitutional rights. Also, to the extent that this is a mode of proceedings error, that is also intertwined with the deprivation of those rights.
Okay, counsel. Thanks, counsel.
Good afternoon, Your Honors. Eric Washer for the Bronx County District Attorney's Office.
Counsel, what's new about all of this? Why isn't this basic apple pie and motherhood?
Well, I think that the starting point is the fact there have been by my count, about 36 reversals since Tyrell. So I think that's a clear indication that something new happened in Tyrell.
36 out of how many cases do you think?
Well, there are a lot of misdemeanor pleas taken in New York City, that's for sure. But 36 is a lot.
Well, that means, counsel, is that there were 36 people in Tyrell's situation, like as your adversary says, like Mr. Conseicao's situation, where everything was done at arraignment and there was no opportunity to actually discuss a plea. It wasn't a pre-negotiated plea. It just happened on the spot.
Well, not all of the reversals have been at arraignments or have involved in arraignment pleas. There have been reversals in other contexts.
Yeah, but if there's supposed to be a reversal, so why is that bad? If we're doing justice and someone's rights were violated, why is that a problem? We're supposed to count them up and say, what if it was 20? What if it was 40? What if it was 60? What if it was 10? What's the difference?
Well, Your Honor, I think I would go back to what Judge Pickett said, that in these situations, the defendant doesn't have to make an allegation that he actually wanted to go to trial or that he actually, as a factual matter, was ignorant of his Boykin rights.
I always have a flip side, though, and one of the ones in this one is that this particular defendant didn't have a lawyer. And I would think if he had one.
Well, he had a lawyer. He had a legal aid lawyer.
I don't have it at the time of the plea. Maybe I misunderstood.
Yes.
Because obviously you want to be able to at least negotiate down from a misdemeanor to a violation.
Right.
Are you talking about the remedy problem? Or what we do afterwards, dismissal or omit?
Well, we don't think that the accusatory instrument should be dismissed in these cases. We think that he should be restored to the pre-pleading status.
Usually the rule is when you look at the cases, and we haven't been here that long, but when you look at the cases, it seems to me that something's dismissed if somebody's already served the time anyway. But here there was a 2-day, he did 2 days in jail and a conditional discharge, so it was an A misdemeanor, right?
Right.
The plea. So he could have gotten, a jail. He could have done 6 to 9 months theoretically. So remittal may be appropriate because, of course, the exercise of the rights is fundamental, but you shouldn't be able to get you should still have to go through the plea negotiation process in a realistic fashion.
Well, yeah.
So I'm assuming that's your position.
Yes, and we think if the harm here is that he didn't understand his Boykin rights, then he should be placed back in a position where he can understand them, and that he can have another allocution. Maybe it'll be more thorough than the one that happened here. But I do think that it's very clear that Tyrell did announce a new preservation rule, which is a state law rule.
Which
so
is
the
what?
Pepper
What
Mitchell,
is the new rule that you think Tyrell announced, counsel?
I think it announced a new exception to the preservation requirement. Lopez, it relied on Lopez and Laurie. Of course, Lopez was a case about factual allocutions. When a defendant says something that negates an essential element of the crime and casts doubt on his innocence or guilt, that's not what happens in a Boykin situation. And Laurie was a PRS situation where the defendant wasn't informed of the post-release supervision component of his sentence. Neither of those things dictated the outcome of the preservation analysis in Tyrell. And I think it's interesting because Tyrell still didn't resolve exactly which preservation exception it relied on. It said this could be a Lopez-Laurie situation.
Exactly.
It could
so
be
we never
Lopez.
committed to this new rule that you're talking about. It could, as I read Tyrell, I didn't take part in that case, but as I read the case, it was either it could be a mode of proceedings error, or it could be Lopez-Laurie
Right.
decay. So we never committed to
Right.
which one. So I don't know where I'm having a little trouble figuring out
think-
what the new rule is.
Well, I think it speaks to the ambiguity that we don't know. We know that there's a preservation exception created in Tyrell because the claims were not preserved in any way, but this Court reviewed them and found that it was preserved. So one way or another, there was a new preservation rule articulated. I think there's just a lack of clarity
But if we
as to
looked
what
at
it
the
is.
totality of the circumstances, there were nothing was done with respect to Boykin rights or any opportunity to consider the offer that was being made, then that would suggest that, you know, that was what was not preserved.
Well,
And we said that in Piquet and Lurie and Lopez.
right, but of course none of those cases involved Boykin. And also, I do think it's interesting that Tyrell didn't cite any cases involving misdemeanors or preservation of misdemeanor cases. Tyrell is actually the first case that discussed, I think, a preservation requirement during a misdemeanor plea allocution. And
Is it really your argument that the custom was that no one did this, and then we said you got to do this, that's what makes the difference? That's what this is, a break from the past? That's what makes this a new rule?
I think there's the preservation aspect that's new, and I do think it is a substantively new rule that requires more than cases like Harris and even Boykin itself had anticipated. Of course, Harris dealt with 6
What's
felony
the more that's
pleas.
required?
Well, I think that there's a way of reading.
Those cases require that somehow the record makes clear that it's a knowing and intelligent waiver. Plea.
Right, but I think where Tyrell took an additional step, it seems to suggest that some of the 3 Boykin rights have to be put on the record. And I don't think any of this Court's precedents make that necessary. Boykin, I don't believe, makes that necessary.
How would you otherwise know?
Excuse me, Your Honor?
How would a judge otherwise know?
Well,
If it's not on the record, how would one know?
Well, here he's with an attorney. The Court will also know that in this particular case, the defendant has 8 prior guilty pleas. He's not a novice to the criminal justice system, which was apparently the case in Tyrell, or at least that was emphasized. And this Court's precedents do say that the defendant's particular circumstances in the criminal justice system, his history in the criminal justice system, are relevant to the judge who's accepting the plea.
Prior misdemeanors in which nobody ever told him about his Boykin rights.
Well, here there were.
Why would you think that he got them in another case if he didn't get them here?
Well, I think it decreases.
You say that's how this goes.
Well, I think it certainly decreases the possibility that he is actually ignorant of his Boykin rights, particularly because that means in 8 prior occasions he's had 8 different attorneys appointed to represent him. And of course, before he took the plea in this case, he did have the opportunity to speak with his attorney. He would have spoke with his legal aid attorney before he took the plea. So he's not going into a situation where he has absolutely no idea what's coming to
So the
him.
presumption should be if you've spoken with your attorney has informed you of these rights.
That's the only reasonable assumption, because every attorney has that responsibility to their client before they allow their client to enter a plea.
And that didn't apply in Tyrell because?
Well, I think the more problematic issue in Tyrell was the first plea. The defendant in that case said absolutely nothing. We don't have that here. The defendant here did say that he wanted to plead guilty. That was a Boykin style.
Represented by a lawyer?
He was represented by a lawyer, but I think
Why
this.
doesn't your presumption hold in that case then?
Well,
Presented by a lawyer, can't we presume the lawyer informed him of his rights before?
well, I think we
Exact
can.
plea.
I think we can presume that. We should presume that, but this court might have been troubled by the fact that he didn't say anything, which is exactly what happened in Boykin. In that case, the judge said nothing about the plea, and the defendant Boykin said absolutely nothing about the plea. That was a totally silent record, and that is kind of what happened in the first Tyrell case that was considered by this court.
Okay, Counsel Stigas?
Thank you, Your Honor.
Thank you. Counsel rebuttal.
Yes, Your Honor. I just want to emphasize again, this case is indistinguishable from Tyrell. In fact, in Tyrell 2, the defendant said a lot more than my client said. In that case, there was a factual allocution. There was a lot less in this case. So this case is completely indistinguishable in every way from Tyrell.
Looking at it practically, I think I understand your argument, but if I picture, the city courts that I'm familiar with and stuff, and pleas are taken and conditional discharges are issued in a fairly routine fashion by the, I don't want to say by the dozens, but certainly substantially a lot of them. Is it your argument that all of these should be set aside now and that all of them should come back or that all of them should be dismissed? Or what's your position with respect to your client is probably a typical one. Is that a fair statement?
Perhaps, but I mean, I can't speak for other cases.
Pretend.
I'm saying that my case is just like Tyrell and
Let's
more.
assume that you win. You win. Tyrell, you win. You go home and you're in glorious victory. But my point is that are there then 50,000 more?
No, there aren't 50,000 more.
Are there 5,000 more?
No, there aren't 5,000 more. I mean, I think the number of reversals, they're in the first 11 months after Tyrell was decided, there were 29 reversals. There have been 20 in the last 11.
Why does it matter? Why does it matter?
It doesn't matter because this is about whether this is, doctrinally there was a new rule in this case.
I guess the question that kind of leaps out at anybody, think if you're not a lawyer, you would say to yourself, you could have gotten a year in jail and you got 2 days conditional discharge, or 2 days of community service and a conditional discharge. Why are we here for this? Why challenge the fact that they didn't read these rights to you? I can see if you're in jail and you've got a more serious crime and it affects your freedom, it makes all the sense in the world. Boykin involved the death penalty. This case is a long way removed from Boykin.
Again, this is a misdemeanor. Misdemeanors have serious consequences.
No, I accept all that. I accept all that. But in this circumstance, if we say, fine, your client the case is remitted, he can withdraw his plea if he wants.
Your Honor, it shouldn't be remitted. In Tyrell,
I understand that, but then why are we here at all if the case isn't going to be remitted? To dismiss the 2 days of community service?
Because it was dismissed in Tyrell, it was dismissed in Moore, it was dismissed in Burwell. The Court's been doing that. This is a 2009 case. To send this back, if the guy did 2 days community service, which he served, would, in my opinion, not make any sense, Your Honor.
Okay, counsel. Thanks. All right. Now we're going to do People versus Perez. Counsel, you want any rebuttal time?
2 minutes, Your Honor.
2 minutes.
Ferguson.
Go ahead. How does your case fit into this?
The issue here is what the appellate division got wrong here. The appellate division got wrong is they came to a determination that it didn't apply because this was a violation. But what they said was that the only consequence of my client's guilty plea in this case was a $100 fine. That's absolutely wrong. A violation has tremendous impacts on people.
You think we trivialize it if we don't take it seriously?
Absolutely, Your Honor. This Court has, from the time of Hildebrand back in the 1950s, has drawn a line of demarcation between traffic offenses and criminal offenses. Whether this constitutes a criminal record or not, it does have serious consequences for the defendant. Your Honor, I know that you are involved with the Columbia University project that indicates all the collateral consequences. My client's violation leads to a 2-year ban from residing in a New York City housing.
I read that, but it's a plea to disorderly conduct, right?
It's a plea to disorderly conduct. And, Your Honor, more importantly, all of us are attorneys. Question number 12 on the bar application indicates have you ever been arrested for a violation? It is something that we as attorneys who are attempting to become attorneys have to present to the bar committee.
Did you fill it out appropriately?
I filled it out appropriately. I have no record, but there have been attorneys who have worked at the legal.
Of course, I don't think we've ever said to somebody, because you were found guilty of disorderly conduct, we're not going to let you be a lawyer.
However, Your Honor, it has been the subject of interviews, and the Bar Admission Committee interview has been related to that.
So we can't differentiate by the level of the criminal
Absolutely not, Your Honor.
violation of
And
crime?
in fact, it would ignore the entire jurisprudence of this court dealing with the
That's
distinction.
here, though. If we look at the Harris, what's on the record? What do we have on the record?
Well,
we know that this wasn't a, arrest, arraignment, and plea all at the same time or in very close proximity. This is a case where it was ongoing for several months, 7 months. This is for a violation. 7 months. And if I don't recall if there were motions but I think it was pretty actively litigated. There was obviously an involved attorney.
But, Your Honor,
why isn't this enough
No.
to say that the record shows that it was
because it would go
voluntary
against what
and-
Terrell said. Terrell imposed an obligation on the court to make sure that there was an understanding of what was going on.
So what was missing here?
What was missing here was if they had asked counsel, did you discuss the constitutional implications
the
of this?
defense counsel went up there. He said, Judge, we have a disposition today for Mr. Perez. He's authorized me to enter a plea of guilty to the added charge of disorderly conduct, yada, yada. The court says, people, is that in fact the offer? Yes. Waiving formal allocution, prosecution. Defense counsel says, yes, Judge. And the court says, Mr. Perez, your attorney's indicated that you would now like to plead guilty to the added charge. The plea is in satisfaction of charges pending against you. Is that a fact you want to do that? Yes. Have you had enough time to speak with your lawyer? Yes. Any objection to the waiver of allocution? No.
But, Your Honor, that's very close to what was in the second Terrell.
What's missing?
What's missing here is any understanding that my client, who was a neophyte to the criminal justice system, this is his one and only arrest.
You have ineffective assistance of counsel here?
It's not ineffective assistance of counsel. What the court could have done is ask counsel, what did you advise him? Did you advise him of his
What is
constitutional
waiving
right?
formal allocution?
Waiving formal allocution.
What's the significance of it?
There is no significance to it. Allocution, if you go back to its etymology, referred to things that the Pope said, a form of creation. That's really what
I
that's
understand
really where it came
that,
from.
but here's the problem. Just like I was asking your co-counsel here. I get all this. I understand. I used to do this, but I didn't do it, saying to my client, I'm going to sit down and tell you, because this is a misdemeanor, you get a jury of 6, you don't get 12, and go through all of this stuff. The guy says, get me the impaired. I'm a driver. I got to get back to work. You got the kid that says, I want to get back to school. Get this out. It's the process. And to say all of a sudden, if I truly believed, if you truly believe, your client said, if somebody told me I was entitled to a jury trial, I'd have been there. That would be a case, it seems to me. But what are we doing?
Of course, you wouldn't have been entitled to a jury trial here.
No, it would have been
That's
just a
for a
trial.
violation.
Because it was
So
added
now
to a
you-
reduced charge.
So
Judge Piggott's giving you the benefit of a doubt
I'm
on
giving
that
you-
one.
yeah.
So finish the answer to your
but go
question.
back to-
Does he have to, how much detail does it have to be about what you spoke to your lawyer about?
I think it has an indication that he understands that he is waiving certain constitutional rights. In Terrell itself, this court indicated.
So you're mandating the litany?
No, I am not mandating
Let me
a
ask you
litany.
this then. On this case, in the totality of the circumstances, if this case in the totality of the circumstances does not meet the Harris test and isn't knowing, voluntary, and intelligent, then we have to overturn Harris on this case, because this seems to be almost requires us to do that and requires a litany.
Absolutely not, Your Honor. What could have been done here was, as this court indicated in Terrell, if a question was posed to counsel and counsel indicated on the record what he discussed with his client.
So do you have to list the 3 different rights? What do you have to do?
Again, I do believe it goes to the totality of circumstances.
So there is no
I don't believe there's a litany, but there has to be something that indicates that.
Tell me what in your plea you would have required.
I would have either had questions asked, getting
What are they?
a waiver from my client, or a statement on the record by counsel indicating that he had advised my client.
Ferguson, what are those questions? You keep saying, I would have, asked these questions. I would have seen that he was satisfied. what would you ask?
I would ask
As the
counsel.
judge.
I would ask counsel. Did you discuss the constitutional rights that your client is waiving?
What constitutional rights?
And that would be the right to trial, the right to the
a
ones that
trial.
were denoted in Terrell. But again, not a
No,
specific.
say it. Tell them. Say it. Because you keep saying we should have said this, and I'm still not sure what we're supposed to say to some kid who's up here in violation for disorderly conduct.
Well, Your Honor, from even the first sentence of Terrell indicated what the three rights were: the right to a trial, the right to confront the accused against her, and the right to remain silent.
You're asking for a litany from the judge. You're asking for a litany. You're asking the judge to ask counsel what is the litany that you gave of rights that you told your client.
Something more than what was here. What we have here is a silent record.
So let's get it precise. Something more than was here, but not the right to the trial by jury. In your case, it's
Right.
not the case. But not that specific, but something more than here. So your basic premise is you got to say that you have to say that yes, discuss the waiving these constitutional rights.
That's correct,
In the
Your Honor.
broadest sense.
In a broadest sense,
Okay.
that's what's not here. And if I could just go back to your question
Can
about
I ask what is waived when you waive the allocution?
What's
You said
waived
it means nothing. It must mean something
well,
to counsel and
It
defense.
seems to be like this pro forma statement. It's our belief, and that's in the parlance of defense attorneys, waiver of formal allocution refers to factual allocution. If you look at the history of allocution over time, how it's meant, originally it was a statement by the Pope, then it became a formal decree, it became something that a defendant would say before sentencing, and then has become factual allocution. It is not defined in the penal law. It is not defined in statute. No court has ever said what formal allocution. And so when my client is told that his attorney waives formal allocution, he has no idea what that is.
You'll have your rebuttal. Let's hear from your adversary.
Good afternoon, Your Honors. May it please the Court. Eric Washer for the Bronx District Attorney's Office.
Counsel, don't you have to have some discussion that you know that you're waiving your constitutional right? You spoke with the attorney. What did you discuss? Doesn't something have to be said that they have the defendant has an understanding of what he or she is giving away here?
Well, preliminarily, I mean, Your Honor, I think the claim is waived. He waived. The defense counsel waived an allocution.
What does that mean? The formal allocution.
It doesn't mean factual allocution, because in this case
What does it mean?
It means an address from the court about all of the consequences that he's pleading. That's the only giving up by pleading guilty. That's the only thing.
So that's enough to say I give up all my constitutional rights. That's translated to mean I understand that I have no constitution. I'm giving them away.
That's enough in the context of this case when he's pleading guilty to disorderly conduct, Your Honor. And that's not
the difference. What he's pleading guilty to.
Your Honor, there is a difference. And Harris,
what's the difference?
Harris makes clear there's a difference, because Harris says that the seriousness of the offense is a factor that the court can consider in deciding the depth of the allocution that is necessary in its discretion. So Harris itself acknowledges there's going to be a sliding scale.
So if it's a lower level violation or whatever it is, basically you give up your constitutional rights because it's not important. Isn't it all crime important? Doesn't it all have its consequence? No matter how minor, if it's criminal, every crime has its consequence.
Of course.
And we do know about collateral consequences. So why does it matter that it's disorderly conduct?
It matters because this Court's precedents, Boykin itself makes clear that the seriousness of the offense is going to dictate the degree of allocution.
We don't know anymore. You can be deported, I think, for possession of marijuana.
Yes, but not for disorderly conduct, Your Honor.
No, but this guy, I mean, I don't know what the other one was about failing to disclose the recording.
But I should say.
My point was only this, that let's assume for a minute that we don't go your way. Is it a big deal to tell somebody who's about to take a plea, you have a right to a trial before a fact finder, and you have a right to remain silent, and they've got to produce witnesses? Do you still want to plead guilty?
It's not a big deal, Your Honor, but and maybe it's the best practice, but the question is, does Boykin require it, and does Tyrell require it, does the Constitution require it? And here, when you look at all of the circumstances.
Doesn't it have to be at least something that translates into what Judge Pickett is saying? Even if you don't say it in those exact words, don't you have to say, listen, you're giving up your constitutional rights here? We didn't even list what the three is. Your adversary says, just get it across that you know what you're doing. What's wrong with that?
Well, his attorney waived allocution. So that in
but
itself,
we're disputing what, that's
Right.
the whole dialogue.
Okay.
What it means to waive formal allocution.
right. And I think it means necessarily the attorney is communicating to the court that the voluntary nature of the plea
That
is
the guy,
not.
he's communicating that the guy said he's given up his constitutional rights?
Well, that's not a great leap of faith here in this case, Your Honor.
Say
Because
that
you
again?
it's not, that's not a great leap of faith here, Your Honor, because in this case, it was adjourned for an entire month so that the defendant could consider whether he wanted
Doesn't
to take the
someone
plea.
have to say, listen, he gets it. We talked about this. He's given up his constitutional rights.
Well,
Is it
defend-
important enough that someone say it?
Well, the defendant in this case told the court he had enough time to talk about the plea with his attorney. That is also record
But
evidence.
that's one step removed from what I'm asking you.
It is one step removed, but I think the only reasonable inference is that he understands the consequences
This
of
is the
his
kind
plea.
of thing that should be done by inference.
Your Honor, we have a tremendous record in this case. This was litigated over 8 months. Motions were filed, hearings were ordered. If you look over time, the plea offer gets better. I think it's.
So in each case, we're going to say, oh, in this case, it's minor, it's been on a long time, he must give up his constitutional rights. One in another case, we're going to say, this is a little more serious, there's a shorter period of time, we need to require. It can't be like that. It can't be by the seat of our pants, right?
No, respectfully, Your Honor, it can be, because we're looking
Can
at.
be by the seat of our pants?
No.
That's how you determine whether you give up constitutional rights?
No, this was not a seat of your pants situation, Your Honor. This was a case that was litigated over 8
Yes,
months.
but
and
I'm
was sought-
saying, doesn't there have to be a common framework, whether it's on one extreme or the other, whether it's saying a litany, you must say I'm giving up this right and that right or the other right, whether you don't really have to say too much of anything and it could all be by inference, or there's at least something concrete that gets across the fact that he understands he's giving up his constitutional rights. It can't be that on each case we figure out, maybe there he should have said it, there he should. There's got to be some kind of rule, some kind of a precedent that we're laying down, right?
But I think that would be a departure from Harris, Your Honor, which says that there does not have to be a uniform mandatory catechism. You have to look at all of the
But there
circumstances.
has to be something, if not uniform, that gets across that you're giving up your constitutional rights. That's not uniformity with a litany of words. It's that we understand on a serious issue of giving up your constitutional rights that that's what you're doing. And if it's not a litany, if it's short of a litany, it can't be nothing. There's got to be something. What's the something?
Well, here, Your Honor, the defendant said he had enough time to talk to his attorney about the plea.
Okay, let's stop.
Okay.
So you're saying the rule is if he says, I talked to my attorney about the plea, good enough.
No, because that's not all we have here, Your Honor. We have the defense.
What's the rule, counsel?
The rule is that you have to look at the totality of the circumstances. You have to look at everything. And you don't have to limit yourself to the four corners of the plea allocution. You can look at everything. Here, there is very compelling evidence that this was a knowing
We have to
involved.
give some guidance, don't we?
Yes, absolutely. But there's also been a rejection of the system that a uniform catechism system. I don't think that that would be any more
Counsel,
meaningful
I
than
guess
what happened
I'm
here.
finding difficulty, and here's where you can help me, is it seems that you're saying a lot of time passed.
Mm-hmm.
He seemed to have had a lawyer who was very aggressive during that period of time.
Absolutely.
He got an even better deal than the one he was offered before.
Mm-hmm.
And that must mean that he understands he's giving up his rights.
That's
It
not.
strikes me that's what I'm missing there, as opposed to that means he understands he's gotten a good offer. I understand your argument about that.
Well, but there is one other piece, and I do think it's significant, that this case was adjourned for a whole month so that he could consider whether he wanted to take the offer.
No, I
Now-
understand. I understand your argument about that he's had a significant amount of time to consider the offer and to
Correct.
consider taking the plea. But the question is whether or not he understands what he's giving up when he does that. He may very well understand what he's getting. The question is, does he understand these rights that he's giving up? So I appreciate what you're saying beyond the four corners of the plea, beyond the transcript of the plea. What else is there? Or is there something specific in the plea that tells us about those rights? I think that's what some of us are asking you about.
Right. Well, No, there is, of course, there's no express mention of the Boykin rights in this case. I mean, that is the issue. But the issue is whether you can glean from everything that happened that this was a voluntary, intelligent
But that's what I'm
choice.
saying. What he refers to is the plea, which is not the rights. I could see your point if the court said, you had enough time to speak to Ms. Gett, the lawyer, about this plea and your rights. And he says yes. I could see your argument there, because you've got the mention of these words and rights. We might not know what they are, but I would see your argument there. Where's the argument about the rights and the understanding of the rights? Does it boil down to the interpretation of forfeiting this formal allocution? Is that really what this is about?
Well, that's a big part of it as well. She's waiving an allocution. I think it's significant for two reasons. One is a preservation reason. The Lopez-Lori exception says that
Does waiving allocution mean the same thing every time a defense lawyer says that? Is it exactly the same thing, regardless of the county, regardless of the judge? Always the same thing?
I think it boils down to the same thing, that he's not going to get, the defendant's not going to get the depth of the allocution that he might otherwise have gotten. Now,
He says it's only about the facts.
I don't think that's reasonable on this record. He's pleading guilty to a bargain for a disposition. He's not going to allocute to the elements of disorderly conduct in this particular case. So I don't think that makes sense.
Do we have to assume that the defense counsel is at least minimally competent and would give some sort of advice about what the defendant is giving up?
Yes, I think we do.
As to what the defendant is also getting?
I think that we can assume that both things happen, particularly when they have a full month to determine the merits of the offer. That we have to assume that she would have explained to him that if he pleads guilty to disorderly conduct, he's not going to have a trial. And I do think the waiver is important. I don't think this claim is preserved. If this attorney had simply said to the judge, no, I'm not waiving allocution. I want you to explain to my client the rights he's giving up by pleading guilty, there would be no error. He would have gone into greater detail.
Thanks, counsel. Okay, rebuttal, counsel.
Your Honor, the record here is silent as to the waiver of my client's constitutional rights. No court has ever defined what formal allocution means. Normal parlance was that it refers to factual allocution. This Court has never held it.
Well, if no one knows what it means, how does the defendant know what it means?
Exactly, Your Honor.
Well, I'm surprised that people don't know what it means. I mean, my goodness, that's about as common a phrase as you'll ever hear in a court. So should we go back, send it back and let the judge explain what he meant by allocution, and then we can...
Absolutely not, Your Honor.
Why not? I mean, it's an important right that he was denied, and he ought to be given it before he decides whether he's going to plead guilty or not, and therefore we should send it back.
Absolutely not, Your Honor. It's our understanding that allocution referred to factual allocution because there is no case that says on record that indicates that waiver of allocution means waiver of your constitutional rights. It means waiver of factual allocution.
Okay.
Well, why wouldn't counsel say that?
What's that?
Why wouldn't defense counsel say that, Judge? We waive factual allocution.
Because it's become almost this cryptic way. It's this pro forma thing that's taken in pleas, which is the exact reason that we brought Terrell here back in December of 2013.
But in those pleas, people don't discuss the rights. So why doesn't it tip the other way? That waiving formal allocution must also include the rights.
I don't believe it does. Again, Your Honor, it would be something that my client, who's a neophyte, if there's never been a court case that indicates, how does my client know that counsel, by uttering a phrase that he has never heard before, is going to understand what that means?
What remedy are you asking? I'm asking everybody this. What remedy are you asking?
I'm going to do this in a practical basis. I was here 2.5 years ago with this court in People v. Wells against the same district attorney's office, who fought tooth and nail. It was a misdemeanor case involving drunk driving. They fought tooth and nail, saying that we should not get Burwell relief, that they were insistent on trying Mr. Wells again. He was never produced in court when it was remanded. The people sua sponte ended up dismissing the case without ever appearing, without even counsel appearing.
So for the people fine, but what about in this case? You got a $100 fine.
We got a $100 fine, Your Honor, and it's many years after it. I believe that the appropriate disposition here would be...
Well, can you make that representation without your client?
Or do you need a formal allocution?
Your Honor, again... It would be if
I'm just picking
no, but Your Honor, just to answer your question, this does frequently come up in this situation, and it is part of the discussion. Whenever we are raising an issue that could result in dismissal or a new trial, and we have not said limit it simply to dismissal, we have an ethical obligation to our client.
Judge Fahey, last question.
Yeah.
Go ahead.
Just so I'm clear, you would check with your client is basically what you're saying.
What was that?
You're saying you would check with your client before you would articulate what remedy you were seeking?
No, we would articulate, yes, before we filed the brief, because if we were simply asking for dismissal,
so here today,
that would be, our goal would be dismissal. We would accept, of course, a reversal, but we think that line of Terrell and what has happened before.
Thanks a lot, guys.
Thank you.
Okay, let's go to the third case, People versus Sanchez.
May it please the Court, Jordan Hummel for the Office of the District Attorney, Bronx County.
Okay, counsel, how does this case fit in with the other two?
This case fits in that the defense counsel waived allocution and that the defendant pled guilty to a misdemeanor.
All right, so what does the waive allocution mean?
So waiving allocution means a discussion between the people, defense counsel as defendant's agent, defendant, and the court about the terms of the plea bargain.
It's the whole kit and caboodle, including your constitutional rights?
Yes, it can be.
How so?
Because it's an accepted term, and I believe that courts have been using this
What about
practice.
Boykin? How does this comport with the spirit as well as the literal reading of Boykin?
Well, I mean, I think the distinguishing factors between Boykin, the fact that Boykin was pleading guilty to 5 felony counts of robbery.
So it's the seriousness. If it's serious, then we got to watch before we give away your constitutional rights. And if it's a less serious crime, we don't have to be so careful.
No, you always have to be careful, but I think that it is a sliding scale depending on what the consequences are going to be for the particular.
I'm sorry, counsel. Let me stop you. Do you want rebuttal time?
Oh, yes, 2 minutes, please.
2 minutes. Keep
Let me-
going. Go ahead. Judge
I
Pickett.
apologize for it, but
No problem.
we keep arguing over what an allocution is.
Mm-hmm.
We say waived allocution, and we talk, when they properly allocute, let's say in a first-degree robbery case, and somebody says, I'm willing to take a plea to a reduced robbery third, what is the allocution that you have to go through to accept that plea if you're a court?
In a robbery case?
Yeah.
I believe that you would need to go through the Boykin rights that we're talking about
Everybody
here.
says
You
Boykin.
would need-
I don't think anybody knows what they are. I mean, what are
I mean,
they?
I don't think Boykin knows what they are. I mean, Boykin listed those 3
What are
rights
they?
as far as a jury trial, cross-examining witnesses, and I'm blanking on the last one.
Self-incrimination.
The privilege against self-incrimination. So those are the 3 rights that Boykin listed, but is this court held to believe
But
in
more than
Harris?
that, if you're pleading out a felony, I think you go into greater detail than that, do you not?
Yes, you would go into greater detail. But in a misdemeanor where you have a
No, I understand that. I'm still back on a definition. So when you're asking a client to allocute in a major felony case, you're asking them a lot of questions,
Yes,
more than the 3.
yes.
And why do you do all that? I mean, what's the big deal?
I think because of the seriousness of the offense and the seriousness of the consequences to the defendant.
Yeah, but you know about collateral consequences. How could you possibly say that in the misdemeanor cases it's less important? There are things that the collateral consequence of a less serious, in quotes, case could be more, have more of an impact than in a so-called more serious case. Isn't that possible?
That is possible, but that's not the case that we have here. A defendant here is
Still,
not.
shouldn't we then take the allocution that you were about to go through with respect to a robbery third and apply it to this DWI?
You could, but I think that you're looking at the totality of the circumstances. So the allocution is one part of it, but we're also going to look at everything else that's happened in the case to understand if the defendant is knowingly, intelligently, and voluntarily taking a plea to that crime and accepting the consequences that are attached to it. In this case, this was a non-incarceratory sentence with the minimum fine that was prescribed by the statute.
But it seems to defy common sense to be saying that the seriousness of the crime determines how seriously we take your constitutional rights. Doesn't make sense.
I think that, I mean...
Wouldn't a better distinction be drawn between non-criminal offenses and criminal offenses? I can see that distinction. Counsel obviously doesn't agree, but that's okay. But what I have a hard time seeing how this wouldn't be a serious consequence. First off, it could set up future charges for felonies in DW. I mean, the endless ramifications. It could have employment ramifications. And it seems an enormous number of civil ramifications. It can affect your insurance rates. It can affect even your ability to drive, which can affect your ability to work. So it can kind of be a life-altering experience for someone to have this kind of a charge on the record. And the law draws a distinction between criminal and non-criminal, which I can rationalize, but I have a hard time rationalizing the difference between the grades of criminality. That seems to me a distinction without a difference.
I think that the best way to distinguish it is between incarceratory and non-incarceratory sentences.
Well, that's a matter of plea negotiation, somebody's criminal record, and you're right, the totality of the circumstances imply that, but it isn't enough in and of itself to dismiss with a litany. The question is whether a litany should be given in all circumstances, right?
Right, and we believe that no litany should be required, then keeping with what this court has said before. And
yeah, but what's a
additionally-
litany? If you don't, is it a litany if you don't list the three rights that you're giving away, but you say, you know, did you talk about, my client talked to me, we talked about he's waiving his constitutional right. Is that a litany? Or is that just enough to let us know that the defendant understands he's given away his constitutional right? You know what I'm saying? What's a litany?
I think that a litany would be where you have to say these three rights that were
Okay,
listed
so
in
let's
Boykin.
let's just suppose that we say you don't have to say that you're giving away, the jury trial, whatever it is. But we do say you do have to understand that you're giving away constitutional rights by taking this plea. What's wrong with that?
I think that, there are many ways to say that. Here, the defense
Let's
counsel...
say if we said it just that way. What's wrong with that?
There's nothing wrong with that. I think that's a great
So
record.
don't you think we should require at least that?
No, because I think that then you are sticking to this script and
Well,
the
what
so-called
about-
line.
How about like in waiver of the right to appeal? What do we require there?
For the waiver and the right to appeal, you have to separate it away from the trial rights.
So we say that there's something that you have to show on the record so that we know that the defendant understood what that meant.
Yes.
Even if it just means, did your attorney explain it to you? You understand it? Yes. Okay.
Yes.
How does that compare to these rights?
I think that is a good comparison, and that you don't have the specific words that you need to say.
But we don't, in the waiver of right to appeal cases, we don't look to the totality of the circumstances and say, even without anything that specifically refers to that right to appeal, we can cobble that together and say, yeah, but it shows that he had time, he talked to his counsel generally, so we can assume that his attorney explained to him what the waiver of right to appeal meant. We don't do that in those cases. Why should we do that here?
I think that we should do it here because there are just, when you're talking about the waiver of the right to appeal, it's just, to me, it's a more limited record. Here, when you're talking about your right to trial, we have defense counsel in this case saying, the case is on for trial today, but my client would like to plead guilty. I think that's strong evidence that the defendant is aware of his trial rights. It's being spoken about in front of him. He says nothing about it.
There's no
He says he
need to
wants
say
plead
anything
guilty.
about giving away rights. Once you say I'm willing to take the plea, I'm taking a plea.
I think where defense counsel has already mentioned some of the rights and where they have also waived allocution, which is a term that they understand or should not be waiving on the record if they do not understand it, then I think that there is no need. When the defense counsel waives allocution, it's as if the court has asked,
When
do
I
I need to
say so,
explain?
your view is if you're taking the plea and if you say I waive further or formal allocution, the two of those together is a waiver of your constitutional right.
Yes, because I think that we can.
In all circumstances.
No, because I think you do need to look at the totality. In a case like this, where it's litigated over 6 months, the case was scheduled for trial, defense counsel says, we're here for trial today, but my client would prefer to plead guilty. I think that shows on the record that the plea was
Let's hear
knowing.
from your adversary, and then you'll have your rebuttal. Counselor.
Christina Schwarz with the Legal Aid Society.
Address what your adversary says. That your adversary says if you take the plea and there's some language about waiving further allocution or formal allocution, you're giving up your constitutional rights. Why aren't you? Why isn't it obvious from all the circumstances that you're giving that up?
Well, just like Mr. Ferguson said, waiver of allocution is an undefined term.
Well, what do most defense attorneys think that means?
In my experience, and I have been a trial attorney in jurisdictions in the First Department and the Second Department. I was a trial attorney for more than 10 years, and now on appeal, I do primarily appeals of guilty pleas.
What do you think it means?
Primarily,
Waiver of allocution, what do you think it means?
primarily it means waiver of the factual allocution.
Okay, so in all of these cases that we're hearing about, where, all of these cases that are up for reversal, and the court isn't mentioning the Boykin rights at all, or even referring to them at all. So what are defense counsel doing there? When they say, I'm limiting it to cases where they waive allocution. So that they're sitting there thinking to themselves, okay, well, I only waive factual allocution, and we're not getting the allocution of the Boykin rights, but I'm just going to sit here and remain silent, and then maybe my client will have a ground for appeal. Is that what's going on?
I don't think that's what's going on.
What is going on then, if this is so prevalent?
Well, I don't know that it's so prevalent. I think there's been 36 reversals. I think primarily most pleas, even misdemeanor pleas at arraignment, do speak about Boykin rights. They can do it very perfunctorily. They can say you have valuable constitutional rights. You're waiving by pleading guilty. Pleading guilty, it gives is.
So in the vast majority of cases, in your opinion, Boykin rights are in some sense directly addressed?
I do believe so, yes.
Well, you just said it. You think that does it?
I think, again, there is a totality of the circumstances. You need to look at the facts of the case. In this case, my client.
But if I'm the judge and I say, by pleading guilty, you're waiving certain constitutional rights, you still plead guilty, I'm covered? I've done it?
Again, I think it's the totality of the circumstances. I think you'd have to look at Harris.
That's the whole totality. I'm trying to pin you down.
Well, I don't think that that's this case, but I can tell you what the Supreme Court said in Boykin. It said.
I understand all that. I read it too. What I'm saying is, you said, a judge can say, do you waive your constitutional rights? And if she or he says yes, then it's over.
I think it would be better to say, do you understand that by pleading guilty, you're giving up valuable constitutional rights?
That's enough.
I think that in many circumstances that would be sufficient.
Why is that enough? Why is that? I mean, I don't even know what my constitutional rights are. When I was asking counsel here, they're flipping back to get the to get.
I'll tell you why. Because with that question, you're opening it up to the defendant to say, "What do you mean?"
No, they're not. Because first of all, the three that you're giving up, I mean, you're not going to trial, and the cop's not, on your case, not going to even testify and say you blew a .12, and that that you're now going to have to say that's what happened. So you've given up your right to remain silent. Where's the constitutional infirmity? I'm just looking at the practicality of this stuff. I'm mystified.
You see, I don't understand what you're saying. By
Here's what I'm
pleading
saying.
guilty, you do have that
You
right.
said, let me
You've
finish.
chosen.
You said all I got to say is you're giving up constitutional rights, and we're done. And I'm saying people don't even know what that means, and yet you think it's okay. And now you're saying, but we have a right to appeal because we weren't told about constitutional rights, that we have no foggiest idea what we're talking about.
Well, obviously, it would be better practice to discuss those rights.
Well, counsel, you're just on this point, you're saying that defense counsel, when they say waiving formal allocution or further allocution means only the factual allocution, what do you think the judge thinks that means? Because the judge is not saying, well, that's nice, counsel, we won't do the facts, but let me make sure that defendant knows that he has some constitutional rights that are being given up here.
In this case, the judge asked counsel, do you waive further allocution, prosecution by information, and adjournment for sentence? 3 things. Those 3 things are guilty plea procedural things. They have nothing to do with a trial. And so that's why I don't think that has anything to do with trial rights.
All the judges who here waive formal allocution or further allocution are thinking, we don't have to ask about Boykin rights because we've already dealt with that because they're waiving formal allocution?
I don't think so, because I think waiving allocution, perhaps it means something like waiving further discussion on the record. That's not the same as.
Let me ask you a question that we've been asking before. In most cases, do you think the judge does say, in addition to your waiving formal allocution, has some kind of colloquy about the constitutional rights?
Yes, I do.
So in the great majority of cases, that's what happens, and that's why you don't get these kind of cases?
Yes, I believe that's the case.
In your experience as a trial lawyer, is that your experience?
Yes, yes, it is.
So the surprise came to your defendant. He found out, after he pled guilty and agreed to drunk driving school, that, oh my goodness, I was entitled to a jury trial, and I was entitled to have people testify against me, and I was entitled to remain silent. And if I'd known that, I never would have pled guilty.
I might have gone to trial with it, yes. It's possible. But it's more important that it is such a fundamental and important right that the case law requires the court to produce an affirmative record.
But
so
that's
it's
not
important.
done.
It's so important.
Let me finish. That's not done when the lawyer says, Judge, I've talked to my client, he wants to plead guilty to the impaired, and he'll go to driver's school.
No, it's done then. It's done then. The judge says, okay, but before I'll accept that guilty plea, I want to make sure that you understand that by pleading guilty, you're giving up a constitutional right.
So your lawyer says you're pleading to an impaired. I'm not going to let you plead to an impaired unless you understand the following rights.
Yes, and I think that's routine. And it's important because...
Why shouldn't the attorney have to alert the judge, hey, Judge, you didn't allocute regarding my client's constitutional rights?
It's the court's duty. It's never been a requirement of the defense to do that. And
It's the court's
again,
burden to do that?
I'm
it's
sorry.
the court's burden.
It's the court's burden.
This is so mystifying to me. I can't tell you the number of DWIs I've been not personally charged with, but involved in as a lawyer. That I mean, you take the plea, you get out, and if the guy's got a CDL, commercial driver's license, he says I can't take the plea. Fine. I mean, then you don't take the plea. But there's never some big discussion about the fact that let me tell you now, if you're going to take this impaired, you got a right to a jury trial. That's what I'm for. That's what the lawyer's for. And my clients generally know what I'm talking about, and they want the impaired, and they're going to driver's school, and they're going to get this thing off.
And that's why I guess, that's why it seems for us, the issue is formal allocution in some form. No matter what you say, we're stuck with some litany that we would have to put in place versus non-formal allocution, which looks at each case in the totality. And I agree with you. Maybe in the totality here, it favors your client. Maybe that's very possible. But it seems the policy choice for us to make is between those two parameters, or those two extremes. One is a formal allocution of the 3 Boykin rights that the courts must give to satisfy that requirement. And some of the appellants here today would argue even in non-criminal cases. And then another is a totality of circumstances test where you look at the 8 factors I think there are in Harris and apply those factors. See, I think Tyrell can be applied within the Harris framework. Sometimes you need to articulate more rights than others, but you have to look at all the circumstances. So the question is, the people bring up to you, they say, this case is down for trial today. So he knows the case is there for trial, and that's a pretty reasonable inference. Is that sufficient in the totality, on the Harris end of the extreme of the cases, to meet the standard here?
Well, I don't think it satisfies the court's requirement of an affirmative record that establishes that it's a knowing waiver of his right. That's not sufficient just to know that it's on for trial.
And the defendant both come to court, it's scheduled for trial. They know it's scheduled for trial. He says he knows it's scheduled for trial, but that's not enough to tell him he's got a right to a trial.
Yes, for Boykin rights, and that's because of case law. Tyrell, Boykin.
I know, but you're making that
they
circular
all
thought then. So then
require-
your argument is we must articulate all 3 Boykin rights on every single plea, on every single criminal and non-criminal offense that comes before us in New York.
I don't think that's what Tyrell and Boykin say. They say that you need to...
Counsel, I don't think that's what you said at the beginning in answer to Judge Piggott. Correct? We're just trying to get what your positions are. Your position is you don't necessarily have to articulate all 3 Boykin rights, but you do have to get across that you are waiving certain constitutional rights by taking this plea. So your position is sort of in between the 2 extremes, or am I misstating that?
That is my position. And I would just say that the Boykin rights are special rights. It's a waiver of the entire trial, the whole shebang, so they require extra protections.
As Judge Fahey said, your client showed up. He's got his tie on. He's ready, to go to trial. Mm-hmm. And he takes a plea. And now we're going to reverse it because he wasn't told he had a right to a trial.
That's right. and that the record is insufficient. And what we're really doing is sending a message to the courts in this state that the Boykin rights, they need to be following Tyrell. They need to be following.
Let me ask you a question, just to be clear about who's got to say what under your scenario. So Tyrell says a valid waiver can be established where the record shows that the defendant consulted with his attorney about the constitutional consequences of a guilty plea. So, if I'm the judge, am I asking that of counsel, or must I ask that of the defendant?
I think either, as long as the record clearly
If
shows.
I ask the lawyer, have you discussed the Boykin rights? Do I even have to say constitutional rights? Can I just say the Boykin rights with your client? And the lawyer says yes. Are we done?
That's a question that I haven't fully thought of because it's not in my case. Because
I'm asking you. You say you're an experienced trial lawyer. I'm asking you.
well, it would be better if it was asked to the defendant for sure.
Yeah,
But
you're...
again, we're going to look at the totality of the circumstances.
Counsel, but I think Judge Rivera is asking you, you know what the Boykin rights are.
Mm-hmm.
So if you're saying as a representative of the court that, yeah, I've talked about my client about it, that means I've talked to my client about the right to trial, the right to not self-incriminate, and all that. So in your mind, you know what you're saying, right?
Yeah, and I would think that it would satisfy it. And certainly, it's a far cry better than saying that waiver of allocution,
Okay.
which doesn't even use the word
Last
trial, or have
question.
anything to do with trial.
I'm just trying to understand why, if you could say as defense counsel, I explained Boykin rights to my client, why couldn't the judge infer that you explain what waiver of allocution means to your client as well? I'm just confused about that.
Well,
there's so much confusion about this waiver.
Waiver of allocution is the same as like waiving further discussion, but it's not the same as waiving the underlying rights. And it's it is a guilty plea procedure. There's no allocution at a trial. So waiving allocution has nothing to do with going to trial. They don't have anything to do with each other. So waiving allocution couldn't equate with waiving.
But if the judge doesn't go further with the Boykin rights or any other constitutional rights, which is what happened here in a number of other cases, then there is some breakdown in communication about what waiver of allocution means between defense counsel and the judge, and defense counsel apparently and defendant. It just seems to me that because then the defendant is left saying, well, what am I here for? I'm just here to take my plea, and let me take it and go. And I don't know what I'm giving up.
Right. Well, right. And that's why the case law requires the Boykin rights to be separate.
I don't know what I'm giving up.
Why the defendant didn't say he did. The question wasn't asked to the defendant. The defense counsel said, sure, we'll waive all of those things, none of them having to do with trial rights.
Okay, counsel.
And then
Thanks, counsel. Let's go to rebuttal.
In this case, it's clear that defense counsel did not think that allocution was limited to a factual allocution.
Well, do the people have any obligation to say anything to the judge? Hey, judge, I think you forgot something here.
I think after Tyrell, where this court has said that, we would like to see this record, that the people are on notice that they should say something. Defense counsel should also say something.
Whose burden is it, counsel?
To create the record?
Yeah.
It would be between the court and the people. But
Don't you think the court has a particular obligation in this regard of everything we've been talking about today? Isn't it the court's obligation to make the record?
They do, and it's defense counsel's obligation to protect the defendant's rights and not misrepresent what they've communicated to the court.
And it's the people's obligation as to do justice, as
Yes.
everybody in this scenario is trying to do.
Of
But
course.
the burden to make the record is the judges.
Yes, but I believe that...
You don't disagree with that, do you?
No, I don't disagree with that, but I believe where defense counsel is representing on the record that they have advised their client, that they told them we're here for trial, but my client wants to plead guilty.
Why doesn't that devolve to just if you're represented by a lawyer, we all presume that the lawyer gave you your rights? Why aren't we back there?
Well, I think because it would be ineffective for a lawyer to allow their client to plead guilty if they thought there was any question that the plea would not be knowing, intelligent, and voluntary, then the defense counsel has no business even partaking in the defendant pleading guilty if they think they really don't understand their rights. If they get
Counsel, but in these kind of situations, the defense lawyer, the prosecutor, cannot fulfill their obligations always perfectly.
Of course.
But someone has the burden here, and the burden is on the judge to ensure that there's a record that people's constitutional rights are protected. What's complicated about this?
I think what's complicated is that courts are relying, properly so, on defense counsel's representations that when they show up to court with a client who wants to plead guilty.
Then your rule is when you come in to take a plea, you've given up your constitutional rights, period.
No, I believe that you
So
need.
what more has to happen?
I believe that if the defense attorney says that they're waiving allocution or further allocution.
So
and
your
then-
rule is if you come in to take your plea and what's said is I give up formal or further allocution, then it's over and you're giving up your constitutional rights.
Again, I think you would need to look at all the other circumstances.
In most circumstances, is that the case?
I think there are too many variables to say whether it is
Let me,
most.
you're charged with 1180D, you're speeding, and you're going to take a plea to a muffler. Do you have to admit that you had a noisy muffler even if you didn't have one?
No, a factual allocution isn't required.
You have to be told that you have a right to a trial in front of a fact finder and that you have a right to a lawyer and you don't have to testify against yourself and they have to produce witnesses against you.
No, I don't think you
Plead guilty
need
to a
that
muffler
entire
violation.
record.
Okay.
Thank
Thank
you.
you, all of you. Thank you. Appreciate it.